And so, good evening again. We'll continue with our discussion and I will finish all topics under obligations of the vendor for tonight para matapos natin. So, from Article 1556 to 1581. Okay, so last week, we've already started with a warranty against eviction. Now we'll continue with warranty against what if the eviction results only into a partial eviction. What shall happen? Okay. Under Article 1556, should the vendee lose by reason of the eviction a part? Okay. So the vendee, the buyer, loses a part of the thing sold of such importance in relation to the whole that he would not have bought it without the said part. The vendee thou may demand rescission of the contract, but with the obligation, of course, to return the thing without other encumbrances than those which it had when he acquired it. So, under the first paragraph, we're talking about a partial eviction and what is the remedy of the buyer or the vendee in case there is partial eviction. Sabi ni Article 1556, if there is a partial eviction or that part wherein it is of such importance that without it, hindi bibilhin yun ni buyer or ni vendee. Therefore, ang sabi ni Article 1556, first paragraph, he may demand for rescission, meaning cancel the contract. Okay? And part of canceling the contract, since ang sabi natin dyan, the vendee already lost a part, meaning that the property is already in the possession of the buyer. So if it's already in the possession of the buyer and you want to cancel it, then the buyer should also return the thing to the seller kung gusto mong i-cancel. Okay, so one of the remedies under partial eviction is rescission. The second is found in the second paragraph. He may exercise his right of action instead of enforcing the vendor's liability for eviction. Meaning, either he go for rescission, cancel the contract, or he files a case against the vendor to enforce the vendor's liability for eviction. So, those are the two remedies of a buyer in case of partial eviction. Meaning, part of the thing has been lost. Okay? What if hindi part of the thing but two or more things have been jointly sold for a sum? Or two or more things have been sold. Okay? The same rule shall apply. Same rule shall apply. Okay? Provided that it should clearly appear that the vendee would not have purchased one without the other. So it operates under the same principle just like a part. Okay? Meaning, kahit pa dalawang objects yan na magkaiba na binenta or binili mo, okay? If wala yung isa, hindi mo bibiliin yung isa, okay? Then you can apply this rule right here. Okay? Para siyang partial eviction na rin. Why? Because what you are going to sell is the two items. If hindi yung two items na yan ang mabibili mo o mabibenta mo, hindi yan bibili ni buyer. Okay, that is partial eviction. Just like what I said, there are two remedies in case of partial eviction, rescission and eviction, and enforcement of vendor's liability for eviction. Okay? Article 1557, the warranty cannot be enforced until a final judgment has been rendered whereby the vendee loses the thing acquired or a part thereof. Okay? Take note, this refers to enforcement of warranty. You can only enforce warranty when there's already a final judgment. Okay? Let's say, for example, that the final judgment has been issued by the court. Sabihin natin, it has been issued by the regional trial court. Okay? Hindi automatic na magiging final judgment yan. There is a certain period wherein the losing party may appeal. Okay? May appeal the judgment. So, habang hindi nag-expire yung period na yun, hindi pa siya final judgment. Okay? Either it's 15 days or iba na yung days ngayon kasi under the new rules, iba na nag-adjust sa days. Okay, but normally during our time, 15 days, okay, during these 15 days, hindi final ang judgment. Let's say, for example, judgment has been rendered today, which is May 5. May 5 until, let's say, for example, 15 days, May 5 until 15 days or May 19 or May 20, okay? Hindi yan final, okay? Hindi siya final judgment. Why? Because these 15 days from May 5 to May 20 is a period for the losing party to either file a motion for reconsideration or an appeal. Okay? Kung wala siyang ginawa during this period, nag-lapse yung 15 days, let's say for example, May 22 na, okay, then the judgment is considered as final. Okay? Kaya, kung merong decision sa RTC, for example, at inappeal ni losing party kay Court of Appeals, hindi pa yun final. Okay? Kasi meron ding period dyan na pwedeng mag-appeal si losing party kay Supreme Court. Okay? Kaya meron tayong remedies. Sakalang magiging liable si vendor, okay, for the warranty when the judgment has become final. And the vendee loses the thing acquired or a part thereof. Meaning meron ng eviction or itong final judgment has already been executed. Hindi kasi automatic yan na, uy, final na yung judgment. Okay? The judgment must also be executed para ma-evict or matanggal yung vendee sa kanyang position. Possession, I should say. Possession. Okay. That's Article 1557. Okay? So, enforcement of warranty. Okay? Article 1558, the vendor shall not be obliged to make good the proper warranty unless he is summoned in the suit for eviction at the instance of the vendee. Okay? So, this one naman talks about how can you make the vendor liable? How can you sue the vendor? Okay? Let's say, for example, A sold the land to B. B now possessed and occupied or acquired the land. Later, after a year, merong lumabas si Party C. Party C filed the case in court against B. Okay? C is claiming that he is the owner of this property and dapat mapaalis si B sa property. Okay? Take note in this case, okay, the vendor is not sued. Diba? Ang sinasabi ni Article 1558, in order to make the vendor liable or in order to oblige the vendor, okay, in order to oblige the vendor, he must summon the vendor in the suit at the instance of the buyer. So, the buyer now may implead the vendor para makasali siya sa case as the proper party liable for that eviction. Okay? Kasi kapag hindi siya nakasali sa case at dito lang, yan, okay, of course, it's only the vendee who will suffer. Okay? That's why ang sabi ni Article 1558, pwede mong i-oblige si vendor as long as you summon him in the suit for eviction. As long isali mo siya sa suit para kapag later on mag-decide ng court, kasama siya sa decision. Okay, that's how you make the vendor liable under Article 1558. Article 1559, the defendant vendee shall ask within time fixed in the rules of court for answering the complaint that the vendor be made a co-defendant. Okay? This is in connection to Article 1558. Ang sabi dito, the vendee shall ask the vendor that the vendor be made a co-defendant. Ito yung sinabi ko kanina. Na kapag kinasuhan si buyer, okay, kapag kinasuhan si buyer, he can implead the vendor para makasali sa kaso. But this time under Article 1559, he can only do that within the time fixed in the rules of court for answering the complaint. Meaning, let's say for example, same example that we had, para hindi kayo malito. A sold to B. B occupied the land. Later on, C came and filed the case in court against B. Okay, yan na yun. When C now files a complaint in court, okay, the court now endorses this complaint to B. Okay, sasabihin ni court, B, merong complaint sa'yo, mag-file ka ng answer mo. Yun yung sabi dito, time fixed in the rules of court for answering the complaint. Ngayon, dun sa answer mo, ang tawag sa final ni C is complaint, yung pagreklamo. Okay, ang tawag naman sa sagot ni B, answer. Okay, kasama na dun sa pag-file mo ng answer mo, i-implead mo na si A. Okay, sabihin mo sa court, ito si A, siya yung vendor, dapat maging liable siya under the law on sales, specifically on warranties, para makasali siya sa kaso. Okay? Within the time of filing your answer, dapat ma-implead mo si vendor. Okay, that is Article 1559. Article 1560 or what we call as warranty against a non-apparent burden or servitude. Warranty against non-apparent burden or servitude. What is warranty against non-apparent burden or servitude? So let's discuss this one by one. If the immovable sold, wait lang, if the immovable sold, ibig sabihin, ang binebenta dito sa article na ito is immovable. When we say immovable, real property or yung mga lupa, mga bahay, mga buildings. Okay? Yan ang immovable. So pag yan daw ang binenta, if the immovable sold should be encumbered, ibig sabihin, merong burden na kasama with any non-apparent burden or servitude. When we say something that is non-apparent, okay, it is hidden or hindi siya easily recognizable. Why? Because it's non-apparent. Hindi siya kita. Kala mo wala. Hindi siya kita. Burden or servitude. When we say burden or servitude, this is a burden imposed on a real property. This is a burden imposed on a real property. Para maintindihan natin yan, we'll discuss more later, okay? Not mentioned in the agreement. Ibig sabihin, nagbenta ka daw ng lupa or building na hindi nakalagay doon na meron pala siyang non-apparent burden or servitude of such a nature that it must be presumed that the vendee would not have acquired it had he been aware thereof. Meaning, if aware si vendee na merong non-apparent burden or servitude, hindi niya sana bibilin yan. Okay? E anong mangyari kung binili niya na hindi siya aware? Ano ang gagawin ni vendee? Ito ang gagawin niya. He may ask for the number one, the first remedy, rescission, cancellation, rescission of the contract. Unless you should prefer the appropriate indemnity. So, it also gives us the second remedy, which is indemnity or damages. So, let's summarize the first sentence of the first paragraph. In case na may mabentang lupa or building, okay, na merong naka-attach na non-apparent burden or servitude, okay, at hindi alamin ni vendee, and if malaman man ni vendee yun, ni buyer, hindi niya sana bibilin yun. There are two remedies by the buyer. Okay? Una, yung sabi natin, rescission. Pangalawa, indemnity or appropriate damages. Okay? Provided, sabi dito, neither right can be exercised if the non-apparent burden or servitude is recorded in the registry of property. So, general rule. Okay, general rule. If there is a sale of a land or a building and it has a non-apparent burden or servitude in which the buyer is not aware, and the buyer would not have bought that property if he was aware, he has two remedies: rescission and interest or damages. I hope that's clear to you by now. Paulit-ulit. Okay? Except daw, okay, except if the non-apparent burden or servitude is recorded in the registry of property. Ibig sabihin, kapag naka-record siya sa registry of property, you cannot exercise these two remedies. Why? Ibig sabihin, you cannot cancel the sale, valid yung sale. Okay? Why? Because recording in the registry of property, I hope you are listening, recording in the registry of property is equal to knowledge. Knowledge by the public. Okay? Just like if you heard the famous, one of the famous or most used lines kapag first year ka sa law is that ignorance of the law excuses no one from compliance therewith. Okay? Ignorance of the law excuses no one from compliance therewith. Meaning, whether you know na merong batas or wala, hindi mo pwedeng sabihin na hindi mo alam na may batas na ganyan. Why? Because the fact that the law is published means that there's already knowledge on you. Let's say, for example, pinanganak ka lang nitong 2000, 2001 or 2000 or 2002. Okay? Meron palang batas na na-enact ng mga 1990 plus or 1980. Okay? Ngayon, nalabag mo itong batas na to and sinasabi mo ngayon sa court, I cannot be held liable because I am not aware of this law. I do not know this law. You cannot do that. You cannot raise that defense and expect the court to hear you and give due course to your defense. Why? Because of the principle that ignorance of the law excuses no one from compliance therewith, We relate that with recording in the registry of property in the sense that kapag ni-record yan sa registry of property, it is equal to the knowledge of the public, meaning it puts the public in notice. Okay, kapag pinarecord mo yan sa registry of property, ibig sabihin, lahat ng tao manonotify. So kahit hindi pa sila manotify, hindi sila aware dun sa recording, they cannot now allege contrary to that. Ibig sabihin, they are now aware. Therefore, yung remedy mo na rescission at indemnity or damages, hindi mo na pwedeng gawin because it is recorded in the registry of property. Unless, ibig sabihin, exception to the exception, there is an express warranty that the thing is free from burdens and encumbrances. Meaning, kapag merong express warranty, babalik ka ulit sa una na meron siyang dalawang remedies, which is rescission and indemnity for damages. Precisely because there is now an express warranty. Okay? So that is warranty against non-apparent burden or servitude. Okay? General rule, if there is a sale of a land or a property or a building na merong non-apparent burden or servitude, okay, there are two remedies of the buyer. Either to rescind or cancel or indemnity or damages. Okay? Except if that non-apparent burden or servitude, paano mo siya i-record sa Registry of Property? If naka-annotate siya, di ba lupa yan, may titulo yan. Okay? Pag nakalagay sa likod ng titulo niyan na meron pala siyang non-apparent burden or servitude, hindi mo na pwedeng i-exercise yung two remedies, yung rescission and indemnity. Why? Because it is already registered in the Registry of Property and registration is equivalent to knowledge. Therefore, you cannot allege that you are not aware of that non-apparent burden or servitude. Exception to the exception if there is an express warranty by the seller. So itong general rule is an implied warranty unless there is an express warranty, then that is the time na babalik ka dun sa general rule na merong two remedies si buyer, which is rescission and indemnity or damages. Okay, I hope that's clear. Within 1 year to be computed from the execution of the deed, the vendee may bring the action for rescission or sue for damages. Meaning, ang prescription, itong second paragraph talks about prescription. Meaning daw, yung remedy ni buyer to rescind and to sue for and to ask for indemnity or damages is only within 1 year from the execution of the deed of sale. Okay? That's clear, 1 year having elapsed, so after 1 year, ang pwede niya na lang gawin, he may only bring an action for damages. So, itong rescission and indemnity or damages may be exercised within 1 year. If naglapse yung 1 year, itong indemnity or damages na lang pwede niyang i-exercise. Okay? Servitude. Ano nga ba yung, ito na, i-explain natin yung non-apparent burden or servitude para malinaw na sa inyo. Okay? Ang servitude or burden, this is an encumbrance imposed on an immovable for the benefit of another immovable. Immovable ang kuha natin dito, hindi tao. Belonging to a different owner. Example. Ito, example lang ng servitude or ng burden. Okay? Let's say, for example, this is a road. Kalsada yan. national or highway, be it anyone. Okay? Say for example, this is a property. This property right here is owned by Mr. A. This property right here is owned by Mr. B. Ito yung sinasabi nating immovable. Okay? Ay, mali pala yung example ko. Dapat pala dito yung isa. Sige, dito na lang isa. This property is owned by Mr. C. This is a government property. Ito ilog. Ito ilog. Tapos ito forest. Yan. Ganyan na. O, basta ganyan. Okay? Sabi dito, ang servitude daw, this is an encumbrance or a burden. Okay? Imposed upon an immovable for the benefit of another immovable. Okay? So how do you apply this in this example? In this scenario, na river ito, dito sa lot na to, si C, wala siyang access sa road, sa daan. Imagine, this is river, this is bundok. Okay, bundok ito. Ito yung daan. A can access the road because A is adjacent to the land. B is adjacent to the land. There's no problem with that. The problem is C. Paano kung may sasakyan si C? Paano siya papasok sa property niya? Paano siya lalabas? Iiwan niya dito yung kalsada. Anong gagawin niya? Lilipad siya dun sa property ni A? Tatalon siya dun sa property ni A? O lalangoy siya dito sa ilog? Pupunta sa property niya? What does the law states? This is what we call easement or burden or servitude of right of way. Ito yung mga narinig nyo sa mga mama, papa nyo, kapitbahay nyo na right of way. This right of way is imposed on an immovable, tama? Imposed on an immovable, imposed on the property of A. For the benefit of another immovable, for the benefit of the property of C. Okay? Why? Para meron namang daanan yung may-ari. Diba? Makalabas, ma-access niya yung road. Kaya siya tinawag na burden, encumbrance, or servitude because it is a burden on the lot of A. Why? Because, di ba, ang lupa niya is ito sana, ito, o yan. Pero dahil sa sa right of way na yan, nabawasan yung area na pwede niyang gamitin and naging limited na yung area niya because of this right of way. That is provided by law. Okay? Sabihin kahit pa-property mo yan, hindi mo pwedeng sarahan yan at huwag padaanin si C. Kasi saan dadaan si C? Sige nga, sabihin ko sa inyo, saan dadaan si C? Okay, hindi mo pwedeng sarahan yan. Kaya nga burden yan sa'yo. Okay, although burden yan, nowadays binabayaran na yan. Okay? Para justifiable naman na mabawasan yung ari-arian niya. Okay, that is an example of a servitude, encumbrance, or a burden. Yan yung right of way na tinatawag. However, itong right of way na to is an apparent burden or servitude. Meaning, kitang-kita siya eh. Diba? Pag pumunta ka dyan, makita mo, mayroong daan. May burden dun sa property ni A. Therefore, kung bibilin mo yung property ni A, aware ka na mayroong right of way si dyan. Okay? As clear as that. Okay? Now, let's go to our example, non-apparent burden. Sir, attorney, ano naman ang example ng non-apparent yung hindi kita? Okay? Punta kayo dyan sa airport natin. Dyan sa Tugigaraw. Or kahit saang airport. O dyan na lang sa Tugigaraw para aware kayo kung nakapunta na kayo dyan. Okay? Pansinin nyo yung mga bahay dyan limited to a certain height. Di ba? Limited to a certain height. Pansinin niyo yung brickstone, limited to a certain height. pansinin niyo yung Robinson limited to a certain height. Why? Because that is also an easement. Okay? That is also an encumbrance, and yan yung tinatawag nating non-apparent burden or servitude. Sorry may ngayong kapitbahay. Okay. Yan. Sorry, naggugulo ako. Ayan. Pansin niyo yung Robinson kung saan kayo pumunta. Matataas ang buildings niya mga yan. Okay. Pero yung nandyan sa sa Penge, kasi malapit siya sa airport, okay, hindi ka pwedeng mag-build ng building na sobrang taas. Why? Because it may obstruct yung mga planes na maglaland dun sa airport. And that is a burden to them. Kasi sabi natin burden or servitude. Burden to those owners na malapit sa airport kasi at a certain height lang ang building nila. Okay, hindi pwedeng tumaas. Okay, that's why this is the best example under Article 1560. Yeah, 1560. Why? Because this burden is non-apparent. Hindi mo kita. Okay, pag binili mo, akala mo walang burden, yung pala hindi ka pwedeng magtayo ng building na mas mataas. Okay? So that is non-apparent burden or servitude. Warranty against hidden defects. Tapos na tayo sa warranty against eviction. Let's go to warranty against hidden defects of or encumbrances upon the thing sold. Okay? Article 1561, the vendor shall be responsible for warranty against hidden defects which the thing sold may have should they render it, una, unfit. Okay? If that defect or that hidden defect would render the thing unfit for the use for which it is intended or diminish its fitness for such use to the extent that had the vendee, same principle as we had earlier, when the buyer should have been made aware thereof, hindi niya bibilin yun. Or, ibibilin niya at a lower price. Yun yung warranty against hidden defects or encumbrances upon the thing sold. Okay? Sorry. But said vendor shall not be answerable for patent defects, of course, or those which may be visible, or for those which may not be visible. But if the buyer is an expert, by reason of trade or profession, must have known them. Okay? So in summary, what is Article 1561? 1561 talks about Warranty against hidden defects. Hidden defects meaning it renders the thing unfit for the use that it's intended, or else it would diminish its fitness had the buyer would have been made aware thereof. Hindi niya sana bibilhin yun. Okay? That is a hidden defect and the vendor is liable for that. Okay? But if the defect is patent, visible, or if it is visible, okay, if it is visible, if it is not, if it is not visible, but the buyer is an expert because of his profession or trade, and he must have known them, okay, then that is considered not a hidden defect, but a patent or visible defect. Therefore, the vendor is not liable under this case. The only instance that the vendor is liable is when the defect is hidden and it renders the thing unfit, or else it would diminish the fitness of the thing. That is a hidden defect. And with that, let's go to the requisites of hidden defects. Una, the defect must be hidden, of course. Diba? Sabi ko nga kanina, di ba? If it's patent, meaning kitang-kita, or apparent, or visible, or although it is not visible, but the buyer is an expert to the point that he has knowledge of it, hindi yan hidden. Ito ang mga hindi hidden. Okay? So, una, it must be hidden. It must exist at the time of sale. Meaning, at the time of sale or the perfection of the sale, meron na yan. It's already existing. It must not exist after the sale or after the delivery. Okay? Must ordinarily be excluded from the contract. Anong ibig sabihin yan? It means that this is an implied warranty. Warranty against hidden defects is an implied warranty, meaning it does not need a provision in the contract to be enforceable. As long as there is a hidden defect, okay, the vendor is liable. Must be instituted within the statute of limitations. Okay? Ang nasa law, which we will discuss later, I think is 6 months. Okay? 6 months. In a sale of goods, there is an implied warranty under the following. Okay? Una, when the buyer expressly or by implication makes known to the seller the particular purpose for which the goods are acquired, and it appears that the buyer relies on the seller's skill or judgment. There is an implied warranty that the goods shall be reasonably fit for such purpose. Meaning, this talks about warranty on merchantability. Warranty on merchantability. Meaning, kapag bumili ka, ikaw na buyer, bumili ka ng walis. Okay? Bumili ka ng walis. Sinabi mo sa seller, pwede ba itong pangwalis? Okay? That is the purpose. Sinabi ni seller, that pangwalis yan. Okay, the presumption is, the seller is guaranteeing or the seller is warrantying to you that that walis is pangwalis. Okay, that's simple as that. Okay, ang winawarranty niya, na yung purpose na sinabi mo kay seller, okay, yun na reasonably fit siya for that purpose. Okay? Bili ka ng cellphone, pang tawag, pang internet, okay, pwede. Because that is its ordinary or particular purpose. Okay? Sabi dito, whether it is expressly stipulated by the buyer, tiyanong niya kung pwede ba itong pangwalis, okay, or by implication, meaning from the appearance itself. Bibili ka ng walis. Para saan? Para pang walis. Okay? So that is warranty on merchantability. Meaning, the seller has an implied warranty that the product that he's selling is really for the purpose that it is intended. Of course, ba't ka magbebenta na hindi niya ma-meet yung purpose niya? Okay? Second one, where the goods are brought by description from a seller who deals in goods of that description, there is an implied warranty that the goods shall be of merchantable quality. Meaning that if these goods are sold to you by description of the seller, meaning you can rely on that description because there is an implied warranty on that it is of such quality as it is described in the description. Diba? Common sense. Diba? Article 1562. It's an implied warranty. Gaya pag bumili ka ng ref or ng washing machine, di ba, doon sa kanyang box, tapos meron pa siyang mga manual, may mga features siya, ayan. Dapat yung mga nandyan, dapat yun talagang nagagawa ng washing machine. Okay, dapat fit siya yung quality niya nandoon. Okay, by description. Okay, yung implied warranty of merchantability, yun yung ordinary purpose or general purpose. Of course, pag binenta mo ang isang ganito ang tawag dito, tumbler, of course, paglagyan ng tubig para may mainuman ka, yung general purpose. Dapat fit siya dun sa purpose na yun. Paano kung bibili ka ng ganito na wala siyang butas or wala siyang mapagkupenan? Paano mo inumin? Paano mo lalagyan ng tubig? Paano mo inumin? Diba? Yun lang naman. As simple as that, yung implied warranty of merchantability. And to add, there is no implied warranty on second-hand articles or second-hand properties. If you are aware that let's say, for example, that cell phone that is being sold to you is a second-hand cell phone, okay, walang implied warranty yan. Why? Because you have knowledge that it is a second-hand article na meron na yung mga defects. Meron na yung mga sakit. Kasi nga second-hand na yan. Hindi mo naman i-expect na yung second-hand article na yan is good as new, good as brand new, and will perform as brand new. Hindi. Okay? So take note of that. There's no implied warranty on second-hand articles. Article 1563. In case of a sale of a specified article under its patent or other trade name, there is no warranty as to its fitness for any particular purpose unless there is a stipulation to the contrary. This is in connection with Article 1562. Okay? Warranty on or warranty of merchantability. Meaning that the product is sold for the purpose that it is intended and not for any other particular purpose. If there is a stipulation or it is stated, sinabi ng buyer na gagamitin ko for this purpose and sabi ng seller, oh, pwede yan, then there is warranty. But with regards to a special purpose or any other purpose, walang warranty. Ang meron lang siyang warranty is with regards to its particular or ordinary purpose. Article 1564 in connection with 1562 and 1563, an implied warranty or condition as to the quality or fitness for a particular purpose may be annexed by the usage of trade. Of course, di ba? Mask, face mask, of course, ginagamit ng face mask, of course, for its usage. It's natural usage of trade. Diba? Of course, dapat din quality yung face mask. Hindi yung babahing ka or hahatching ka, tatagos lahat doon. Particles mo dun sa face mask. Okay? Okay, that's 1562, 63, and 1564. Let's go to 1565, another warranty of merchantability in case of a sale by sample. So yung kanina, by description, dito naman by sample. If the seller is a dealer in goods of that kind, there is an implied warranty that the goods shall be free from any defect, rendering them unmerchantable, which would not be apparent or on reasonable examination of the sample. Meaning, na dapat yung binebenta mo by sample, kung ano yung sample na pinakita mo sa buyer mo, dapat ganun din yung product na later on na ibebenta mo. Okay? Kasi kung kine-claim mo na, say for example, meron siyang special features, di ba? Tapos later on, yung dineliver mo, wala siyang special features, ordinary lang pala na product. Okay? That means it may be unmerchantable. Okay? Because that is not what is indicated in the sample that you presented. Take note, this is a sale in case of a sample. Article 1566, the vendor is liable or responsible to the vendee for any hidden faults or defects in the thing sold, even though he was not aware thereof. So general rule, take note, the vendor is liable whether he has knowledge or not. Okay? So liable siya for hidden defects. Okay? Sabi ng batas yan. Whether alam niya or hindi niya alam, liable siya for hidden defects. Okay? Pag alam niya, may dagdag yan na damages kasi bad faith aware siya eh. Kapag hindi niya alam, baka yung value lang. Okay? However, sabi, this provision shall not apply if the contrary has been stipulated. Meaning, mayroong stipulation dun sa contract. Okay? That the vendor, okay, cannot be liable for hidden defects. Okay? So, this is the exception. The general rule, the vendor is liable to the vendee whether or not he has knowledge or he has no knowledge of the hidden defect. So, whether aware siya or hindi, liable siya. Hindi siya magiging liable. The vendor shall not be liable with regards to hidden defects if there is a stipulation in the contract. Okay, and that, yan yung first na requirement. There is a stipulation in the contract and that he is not aware or not knowledgeable of that defect. Meaning, if you are in good faith, then you can raise a defense. Okay, basta merong stipulation sa contract. Kung walang stipulation sa contract, balik tayo sa general rule na whether the vendor is liable or not, whether the vendor has knowledge or not, he is liable to the vendor. Okay, that's Article 1566. 1567 talks about the remedies of the buyer, vendee or buyer in cases of 1561, 62, 64, 65, and 66. In these cases, ang remedies ni buyer is to withdraw from the contract and reduce the price. Okay? Plus damages in either case. Okay? Okay, sorry. Hindi ko na magawa. Wala na akong magawa dyan sa ano. I just hope you can hear my discussion. Okay, so for the remedies of the Vendi under 1561, 62, 64, 5, and 6. Okay, the remedies are withdrawal plus damages, meaning you can withdraw or cancel the sale, or reduce the price plus damages, since this is hidden defects. Okay, okay? 1568, if the thing should be lost. So, dito naman daw, paano ko na-consider? Hindi naman sa lost na lost, but there are definitions of loss under the law, di ba? Pwedeng na lost yan because unfit na siya, di ba? Hindi mo na siya magamit. Because of hidden faults or hidden defects. Liable si vendor if he was aware of them. Okay? He shall bear the loss and shall be obliged to return the price and refund the expense of the contract with damages. So, if the thing is considered lost because of the hidden faults or defects, and that the vendor is aware or have knowledge of them, the vendor shall bear the loss. Number one, bear the loss. Number two, return the price and refund the expenses with damages. Okay, with damages. So, if the thing is subsequently lost in consequence of hidden faults or defects and the vendor has knowledge of them, the consequences are that the vendor shall bear the loss, okay, shall reduce the price, shall refund the expenses plus damages. Okay? Paano kung hindi siya aware? If he was not aware, he shall only return the price and interest thereon and reimburse the expenses incurred without damages. Why? Because of good faith. Take note, basta civil code, basta bad faith yung party, automatic liable yan for damages. Pero pag good faith yung party, hindi siya liable for damages. Take note for civil code. Okay? Basta bad faith yan, kung hindi nyo alam yung isa sa mga sagot, ang isang claim ng party na kalaban niyan is damages because he is in bad faith. Okay? 1569 naman. Okay? There is a loss, but this time hindi na because of hidden faults. There is a loss because of fortuitous event. Diba? Or to the fault of the vendee. Diba? Fortuitous event, those acts, itong mga fortuitous events na ito, these are the events that cannot be foreseen, or if it can be foreseen, it cannot be evaded, di ba? Fortuitous events, or because of the fault of the vendee. Ano ang remedy ni buyer? The latter may demand that the vendor of the price which he has paid, okay, less the value which the thing had when it was lost. So, kapag nawala yung property or considered as lost, not because of hidden defects, but because of fortuitous event or to the fault of the vendee, the buyer himself, okay, the vendee may demand for the price minus the value when the thing has been lost. Okay? So if let's say for example, 300,000 yung price niya, 150 yung value niya at the time that is lost, then the vendee may demand for a price of 150,000. Okay? Tapos, dun sa last, makita nyo, if the vendor acted in bad faith, he shall pay damages. Diba? I stressed this one kanina. Basta bad faith, liable for damages. Kahit sinong party pa. 1570, of course, lahat ng preceding articles applicable also to judicial sales or to the sales as ordered by the court. Okay? 1571, actions arising from the provisions of the preceding 10 articles, okay, shall be barred. Ito na yung prescription na sinasabi ko kanina na 6 months. Okay, 6 months from the delivery of the thing sold, you can enforce the warranty against hidden defects. Basta warranty against hidden defects, 6 months. Okay? Yan, malapit na tayo. Ngayon naman, tapos na tayo sa things. Let's proceed to animals, mga hayop. Diba? If 2 or more animals, sabi niya, if two or more animals, yan, are sold together, nabenta sila together. Either for a lump sum, isang presyo lang silang tatlo, or meron silang tigi-isang presyo, separate price. The redhibitory defect, take note of this, the redhibitory defect of 1. Kung may redhibitory defect daw yung isa, shall only give rise to its redhibition and not that of the others. Kung ito lang yung may redhibitory defect, siya lang yung merong redhibitory defect. Hindi kasama ito. Okay? Sabihin kung ito merong defect, okay, ito malinis. Hindi mo pwedeng sabihin na malinis silang lahat. Okay? That is the general rule. Okay? Except, sabi ni Batas, unless it should appear that the vendee would not have purchased the sound animal or animals without the defective one. Diba? As we have encountered time and again kanina, if hindi bibilhin ni buyer ito kung wala yung isa, then therefore, pwede niyang consider as reddivision as a whole. Okay, reddivision as a whole. Pwede niyang hindi bilhin ito as a whole. Okay, why? Because the vendee would not have purchased the 2 other animals kahit pa sound sila or kahit pa okay sila without the other. Okay. Yan yung first paragraph na Article 1572. So, to reiterate again for the last time, okay, if 2 or more ang binentang hayop, whether for lump sum or separate price, okay, kung merong redhibitory defect yung isa, hindi ibig sabihin meron ding redhibitory defect yung dalawa. Kung may redhibitory defect yung isa, siya lang ang merong redhibitory defect. Okay? But if ang tenor ni buyer or ni vendee is that gusto kong bilhin yung buo eh. So kung sinasabi mong may redhibitory defect yung isa, hindi ko na bibilin, pwede niya consider as reddivision nung buong nung tatlong hayop na binibenta mo. Okay? The latter case shall be presumed when a team, yoke, pair, or sets both even if a separate price has been fixed. Meaning, if binili mo yung buong anak ng isang kambing or yung buong family ng isang kambing, ibig sabihin, presumption yun na binibili mo silang lahat. Therefore, kung may redhibitory defect yung isang kambing, may redhibitory defect na lahat. Okay? But the general rule is, redhibitory defect of one animal shall not give rise to redhibitory defect of other animals. Exception, if the buyer would not have bought the sound animals without the defective animal. Okay? 1573, the provision of the preceding article, meaning 1572, with respect to the sale of animals and in like manner be applicable to the sale of other things. So, hindi lang siya applicable for animals, pwede rin sa things. Meaning, kung may defect yung, let's say for example, 3 bagay na binili mo, kung may defect yung isa, hindi ibig sabihin, may defect na rin tong dalawa. Okay? But if gusto mong bilhin yung buo at hindi mo bibilhin itong dalawa kung wala itong isa, okay? Then pwede mong i-treat as may defect silang lahat. Okay? That's 1572 and 1573. 1574, no warranty against hidden defect of animals in the case of sale in fairs, public auctions, or livestock sold as condemned. So, if the sale is held in a fair, sa mga pista, sa public auction, or sa mga livestock sold as condemned, walang warranty against hidden defect of animals. Why? Because there is already a presumption that these animals may indeed have defects. Okay? Kaya walang warranty dyan. 1575 naman speaks about sale that is void. How can a sale of animal be void? A sale of animal shall be void if the animal is suffering a contagious disease. Take note, pag contagious disease, void. Ibang contagious disease sa redhibitory defect. Okay? A contract of sale of animals shall also be void if the use or service for which they are acquired has been stated in the contract and they are found to be unfit therefore. Okay? Let's say for example, bumili ka ng kabayo kasi gusto mong pumasok sa business ng pagkakalesa. Ngayon, nabili mo yung kabayo, akala mo 4 yung paa, nagulat ka pala na pilay pala yung kabayo na yung isang paa pala niya is kahoy. Hindi mo napansin. If that would render the horse unfit na magkalesa, then that sale could be considered as void. Take note, the primary consideration here is that if the use or service for which they are acquired has been stated in the contract and they are later on found out to be unfit. Okay? Article 1575. Article 1576, if the hidden defect of animals, ito yung definition ng redhibitory defect. Hindi ko alam kung bakit na-delay or late nilang nilagay yung definition ng redhibitory defect. Dapat sa una ito. If the hidden defect of animals, even if merong professional inspection, should be of such nature that expert knowledge is not sufficient to discover it. Meaning, talagang hindi mo makikita eh. Redhibitory defect is equal to hidden defect, di ba? Even if merong professional inspection, meron ng expert knowledge, hindi mo pa rin siya makita. Ang tawag dyan, redhibitory defect. That is redhibitory. Okay? But if the veterinarian, through ignorance or bad faith, should fail to discover or disclose it, he shall be liable for damages. Sabi naman dito sa second paragraph, pero kung discoverable naman, pwede mo siyang makita. Pero hindi nakita ng veterinarian, pwede pa siyang maging liable for damages. Yun siya. So, ang hidden defect na sinasabi natin a while ago with regards to things, ito yung redhibitory defect with regards to animals. Even with the professional inspection and expert knowledge, hindi mo siya makita, pero mayroon siyang defect. Okay? That is redhibitory defect. Prescription of redhibitory action, 40 days. 40 days from the delivery to the vendee. 40 days from the delivery to the vendee. The action can only be exercised with respect to faults and defects, meaning that within 40 days from your receipt of the animal, okay, you can file for redhibitory action. Kung nag-lapse na itong 40 days, then hindi ka na pwedeng mag-file for redhibitory action because the presumption is pag lumampas ka sa 40 days, baka naman na-acquire niya na yung defect na yan nung nasa iyo na bayad. Okay, kaya 40 days lang yung prescription. Kaya kung meron kang napansin na redhibitory defect ng animal, as early as possible, you should file redhibitory action. Otherwise, it will prescribe after 40 days. If the animal should die within 3 days after its purchase, the vendor shall be liable if the disease which caused the death existed at the time of the contract. Okay, so hindi siya automatic. Let's say, for example, may binili ka na animal, the animal died within 3 days. So, date of purchase, 1, the first day, the second day, the third day. Let's say, for example, namatay yung animal within the second day. Automatic ba na liable si vendor? No, it's not automatic. Ang sabi dito, the vendor shall be liable if the disease which caused the death existed at the time of the contract. Meaning, you have to prove that the cause of death or the disease existed prior or at the time of the contract. Dapat nung binili mo, maipakita mo na may disease na yung animal. Otherwise, the vendor is not liable. So if you are able to prove na there exists a disease which caused the death of the animal at the time of the purchase, then that is the time that the vendor is liable. Okay? But if you are not able to show that the disease existed during the time of the contract, then the vendor is not liable. That is Article 1570. Article 1579, if the sale be rescinded or cancelled, the animal shall be returned in the condition in which it was sold and delivered. Okay? So parang yung principle lang natin dun sa sale ng thing, di ba? If i-exercise mo yung action ay yung remedy for rescission, then you are obliged to return the thing. Dito naman, you are obliged to return the animal in the condition in which it was sold and delivered. Therefore, if binili mo yan, let's say for example, baka, binili mo yung baka na yan, na 4 ang paa, dapat isoli mo na 4 ang paa. Baka isoli mo, 3 na lang paa niya. Okay? If that's the case, you may pay for the value of that leg. Okay? But if the sale will be rescinded, automatic yan, dapat ibalik mo din yung na-receive mo. Whether gamit yan, thing, or hayop, ibabalik mo yan. At the state wherein it was sold and delivered. So kung ano yung status niya na nakuha mo, dapat ganun mo din siya ibalik. Okay? The vendee being answerable for any injury due to his negligence and not arising from the redhibitory fault or defect. Meaning, okay, if, gaya ko ang sabi ko kanina, kung 4 yung legs ng kalabaw, dapat 4 na ibalik mo yan. Pag naging 3 yan, at nangyari yan because of the negligence of the vendee, liable ka dyan. But if naging 3 yan because of a redhibitory defect existing during the time of sale, then pwedeng hindi ka maging liable dyan. So that's a defense. Okay, that's Article 1579. Article 1580. Okay, in case of redhibitory defects, ito yung pwede mong remedies. Okay? First is withdrawal plus damages. Same dun sa kanina, hidden defects, and reduction of price plus damages. So withdrawal plus damages and reduction of price plus damages. The form of sale of large cattle shall be governed by special laws because of frequent theft of cattle, di ba? Meron tayong tinatawag na anti-cattle rustling law. Meaning, kapag nagbenta ka na ngayon ng baka, kalabaw, basta large cattle siya, pumasok siya na large cattle, meron niyang form provided by anti-cattle rustling law. Yung form lang, with regards to its essential principles and policies, mag-prevail pa rin ang civil code. Pero with regards to form, meron ding parang birth certificate or title yang hayop. Okay? Kaya meron silang papel yan. Kapag nahuli ka na nagtra-transport ng large cattle na wala kang maipakitang dokumento na binili mo yan, wala kang makipakitang papel, okay, pwede kang huliin, pwedeng confiscate yan sa'yo, pwede ka ding makulong. Okay? That is Article 1581, the last paragraph under the obligations of the vendor. Next meeting, we'll proceed with the obligations of the vendee. Okay? So questions? If meron bang questions? If none, let's call it a night. Medyo malakas na yung video. Okay, good night. Good night, everyone. Good night.
Good night po, sir.
Thank you po, sir.
Thank you po, sir. Thank you po, sir.
Thank you po, sir.
Thank you, sir.